Hi, welcome to another episode of Videos from the Ville. This is a video for state and local government, for Government 112. I'm Professor Greenawalt, and this presentation is on state and local government judiciary. So today we're going to look at the judicial branch of government. And the first thing that we'll have to note is the uniqueness of the American judiciary. America's judiciary is unique because it is more involved. It has a greater influence on the final outcome of public policy making than any judicial branch anywhere else in the world. Why is the American judiciary the strongest judiciary in terms of its effect on public policy making? Well, the answer lies in something we've talked about before, and that is judicial review. Presence of judicial review allows the American judiciary to be far stronger and far more influential in public policy making than any other national regional judiciary. We find that of course, judicial review is the ability of the courts to do what? The ability of the courts to strike down legislation that has been passed by the state legislature and signed by the governor at the state level, or at the national level, passed by the Congress and signed by the president. How does judicial review work? Well, judicial review, we've gone over this before, but it's important to remember. There has to be first what? There has to be a real grievance. Cannot fabricate a grievance or make one up. There has to be a real grievance. That grievance has to be litigated. It has to take the form of a court case. Number three, that court case has to be appealed all the way to the state Supreme Court. And number four, the state Supreme Court has to consciously decide to invoke judicial review. The origins of judicial review can be found in an 1803 decision by the United States Supreme Court, Marbury versus Madison. And this was an opinion written by the Chief Justice John Marshall, the Federalist from Richmond, Virginia. And in that he says what? He says, "It is emphatically the province and duty of the judicial department to say what the law is. It is emphatically the province and duty of the judicial department to say what the law is." In other words, it refers back or harkens back to that old saw that we've heard over the years, that what is the Constitution? Well, the Constitution is whatever the Supreme Court says it is. And that's not just true at the national level, but it's true at the state level as well. Well, when we turn to look at Pennsylvania's judicial system specifically, we find that the quality of Pennsylvania's judiciary traditionally been one of the lowest in the country. And what are the reasons for the poor quality of Pennsylvania's judicial branch? Now, when I'm saying this, one should understand that there are fantastic judges in Pennsylvania. There are judges in Pennsylvania that are the equal of judges anywhere in the nation. But when we look at the system as a whole, we find it wanting. What are the weaknesses of the Pennsylvania judicial system? Well, one traditionally has been the compensation level, that judges simply weren't paid enough. If you are a superb lawyer in, say, Lancaster County, you are one of the best lawyers, it's not unrealistic to think that you might make $1 million a year. If you're a good lawyer, you probably make maybe $250,000. But if you are a judge, what was true in the past was that you would make considerably less money than that. And why should a good lawyer take a pay cut to sit on the bench? Well, luckily there are a few individuals who want the status of having been a judge, want that on their lifetime resume, and some individuals have a family tradition of sitting on the bench. So there are some good people that we get that way, but we find that very few, if any, lawyers run for a bench position because of the pay. The pay has been poor for many, many years. Several years ago, when we had the nighttime pay increase, that led to the upheaval in the state legislature when so many members lost their seats at the next election. This was a pay increase that was generated by the court system. At the time, the Chief Justice of the state Supreme Court was Ralph Cappy. Ralph Cappy decided that yes, jurists didn't make enough. It was true. So he went to Governor Rendell, and Governor Ed Rendell agreed as well. But he said, you know what? It's not only that you, the judges, don't make enough, but my cabinet members don't make enough either. So how about if we go to the legislative leadership and we ask them to increase the salaries for the judiciary and for my cabinet members? So they did that. They met with the leadership of the Senate and the House, and it was my old boss, unfortunately, who was involved with that. Senator Jubileer did agree that these salaries needed to be increased. The perhaps ill-considered portion of that deal was that they decided to raise the salaries of all state legislators as well. And it simply looked, the optics on the situation weren't good. They passed this into law, I believe, at 2 a.m. In the middle of July. And just looks like they passed it in the middle of the night when no one was around, and they hoped no one would notice. There was a public reverberation, a public outcry, but the legislature and the legislative staff believed that it would go away over time. In this instance, surprisingly, it did not. For almost a year, you had the editorial writers, the papers of Pennsylvania standing together, along with virtually all the radio talk show hosts in Pennsylvania, whether they be from the right, the left, or the middle. They were all opposed to this and thought it was ill-conceived. And the criticism levels just grew and grew and grew until eventually the legislature relented. They did away with those salary increases. Interestingly enough, the judges did get to keep those salary increases, and they really needed them. But the salary increases for the other individuals were removed at the time. We find that the members of the legislature who voted for that pay increase in many instances then paid at the next election by being defeated. You find that compensation level has been hard to raise up, but now we find that at least it's at a reasonable level, and it's not quite as, it's not so depressingly low as in the past. So that's one reason why Pennsylvania's judiciary is perhaps not the finest in the country. They aren't paid really, really well. Secondly, is the method of selection. How do states decide who's going to be a judge? We do it here in Pennsylvania through elections. These elections are similar to student council elections in high school. Who has the best name recognition? How many of you, I ask, study judicial candidates and judicial issues before you go to the polls to vote for judicial candidates? I would think that very few of you. Most of you, if you even vote in a judicial election, simply go and vote the party of your choice and don't do any homework on this choice that you are making, I would say. You find that there are a number of ways to select judges, but we probably have the poorest, and that's that we elect our judges. And for many, many years, this system was compounded by the fact that we had something in Pennsylvania at work called the Canon of Judicial Ethics, the CANON, the Canon of Judicial Ethics. The Canon of Judicial Ethics said to judicial candidates that you should not speak about, you should not talk about the issues. You can talk about who you are, where you went to law school, who you might be married to, you have children. So voters end up voting for, what they consider to be the best law school, or which family looks the nicest on campaign materials. But we find that they would never talk about judicial philosophy. Well, several years ago, the United States Supreme Court said that judicial candidates have every right to talk about their judicial philosophy and judicial issues. Now, what has transpired, what's happened in Pennsylvania and other states where the canon of judicial ethics has been used, is that candidates for the Pennsylvania Judiciary have continued to follow it. It is so much easier to tell someone in a campaign, oh, I can't talk about that issue because of the canon of judicial ethics. Luckily, I found out about this change at the national level at the U.S. Supreme Court. So in my county, when we called some judicial candidates in to the executive committee of my party to make an endorsement, to see if we wanted to endorse in that race, and if so, who did we want to endorse. And I think there were 6, I believe, judicial candidates that night. Everyone was asked if they would share their judicial philosophy, and with the exception of one, all of them demurred. All of them said, no, we can't do it because of the canon of judicial ethics. I pointed out to all of them that they could do it. But for example, there was a response that not until the state Supreme Court says that I can do it will I do it. Well, it doesn't matter what the state Supreme Court says when the United States Supreme Court has already struck it down. So the canon of judicial ethics is out there, and makes it much more difficult to find out what the judicial philosophy of candidates for the bench are. What are the other methods of judicial selection? We have election, as we have in Pennsylvania. We have appointment. Appointment is generally done by the governor or by a blue ribbon commission of retired judges, retired legislators, and distinguished businessmen or citizens from the state. And generally the governor would be appointing on their own or appointing from a list that a blue ribbon commission might give them. Or we can have a combination method, and the most famous and best known combination method is called the Missouri system. The Missouri system is appointment and election combined. What you have in a Missouri system is that a commission gives a list of names to the governor of individuals that he or she could choose to be a judge. And the governor will choose an individual from this list, and that individual then will sit on the bench for a year. And after a year, then they will have to face what is called a retention election. The people of that jurisdiction will be asked, do you want to keep so-and-so as your judge? Yes or no. And if they survive the retention election and everyone votes yes, then they will continue as a judge. If they vote no, they will have to leave, and the governor will have to appoint someone else who will serve a year and then will face a retention election as well. So the methods of judicial selection are election, appointment, and the combination method. I think the combination method has proven itself as fairly reliable. Now, when we look at selection to the federal judiciary, of course, all federal judges serve for what? They serve for life. What a wonderful job. They serve for life unless they're impeached and convicted. But you find how do they become members of the federal judiciary? They have to be nominated by the president and confirmed by the U.S. Senate. And we find that the process became highly politicized in the aftermath of Vietnam and the aftermath of Watergate during the administration of Ronald Reagan. During the administration of Ronald Reagan, he decided to appoint, I would say, the individual who had distinguished themselves as the most outstanding and most thoughtful judge in the federal judiciary at that time, and that was Robert Bork. Robert Bork, however, was an originalist. He believed that the Declaration of Independence is part of, as a preface to the Constitution, and if you believe that to be true, what does the Declaration of Independence guarantee us all? Life, liberty, and the pursuit of happiness. But life. That means that Judge Bork was a pro-life candidate for the court. And because he was pro-life, all of a sudden this issue became highly polarizing, and Senator Ted Kennedy from Massachusetts rose up and opposed the nomination of Judge Bork. And this continued for some time till finally Judge Bork decided that that this would be just as well to withdraw. And this issue became a real ignition point for the nomination and confirmation process. You find finally there was a judicial nominee from New Hampshire that solved this problem, and almost all, with the exception of perhaps two, nominees to the United States Supreme Court since that time has used the same strategy. You find under President Bush Sr., his chief of staff was former governor of New Hampshire, John Sununu. And Governor Sununu recommended to President Bush that he consider for a Supreme Court nomination a little-known justice on the New Hampshire State Supreme Court by the name of David Souter. President Bush decided to act on that recommendation and nominated David Souter. And what did David Souter do? Well, David Souter simply, when confronted with questions that were trying to pin him down as to if he was pro-life or pro-choice, he simply said, I don't know, I don't have a case before me. These are all hypotheticals that you're giving me. I couldn't rule one way or the other on this issue. I would have to have a concrete case in front of me. So this tactic worked for Judge Souter. He was confirmed to the United States Supreme Court, and we find that since that time, with the exception, for example, of Judge Roberts, who was nominated by President Bush Jr. to be both the Chief Justice and a member of the U.S. Supreme Court. With the exception of him, all members have been nominated. All nominees for the United States Supreme Court have followed in Souter's footsteps and have said they simply can't say, they don't know, that these are hypothetical questions, and they simply dodge the questions and refuse to answer. Now Judge Roberts, he sat at the table confronting the Senate Judicial Committee for a week without a note, without anyone sitting beside of him, and he presented a real tour de force. He was asked about all types of national and international law and every possible situation that one could encounter while a judge, and he didn't blink an eye. He waded through the questions for a week and came out on the other side being confirmed. I find that is a rarity today in that particular process. Well, let's turn to the national judiciary. We find that when we look at the national judiciary, there's really three eras of judicial history in the United States. The first era runs between 1787 with the development of the Constitution Constitution, and 1865 at the end of the Civil War. This first era of American judicial history was one in which what? This was an era in which most of the important cases before the United States Supreme Court dealt with the issues of national supremacy versus slavery and states' rights. And you find that the Supreme Court was struggling to address those issues during that period of time. The second period in national judicial history was between 1865, the end of the Civil War, and the 1930s. During this era, we find that the Supreme Court dealt primarily with issues having to do with the relationship between the government and the economy. Here you have antitrust legislation being developed, and the court having to deal with those issues. And then we have the last period of American judicial history, which we're still in, that started during the New Deal, the 1930s to the present. Here we have that most of the outstanding cases, some of the most significant cases in American judicial history, or from 1930 to the present, they have to deal with the issues of political liberty and economic regulation, and what are the dynamics between them, between political liberty and economic regulation. We have this tendency that we want to promote equality, but on the other hand, when you're promoting equality, you're removing freedom and liberty in many instances. So many of these court cases have dealt with that tension in public policy. Well, let's take a look at the structure of the judiciary in Pennsylvania. At the lowest level, what's the lowest level of the Pennsylvania judiciary? It's the district justice, isn't it? Or what's called justice of the peace in many parts of America. The district justice, what are the requirements for a district justice? You do not need to be a lawyer, but if you are elected as a district justice, you may not serve as a district justice until you complete a course in Pennsylvania law and Pennsylvania legal procedures. This course is offered by Wilson College. This was the all-girls, all-women's college in Chambersburg, Pennsylvania. We find that district justices are aspirants for that office, or people that had won that office. Everyone who hoped to serve as a district justice, you'd have to go to Chambersburg, and the course was only offered in the summertime, and I believe it was 2 to 3 weeks. I think, 2 to 3 weeks. You find that now, in response to criticism, that course is available now in Pittsburgh, and it's available in Philadelphia, Harrisburg, and in Chambersburg, and it's available several times a year now. But you do not have to be a lawyer. You just have to complete and pass that course. You find that a district justice has a 6-year term of office, and one may run for re-election. The interesting thing is that there are only 2 positions in Pennsylvania that you can cross-file for. You can run in the primary both as a Republican and a Democrat. One is the school board, and that's exactly what I did when I ran for school board. I cross-filed and ran as a Democrat and a Republican, and the district justice level. So probably smart if you win, as I did. If you win on both tickets, then you're guaranteed to be on the ballot of both parties come the fall in the primary election, and it's impossible for you to lose. But in the case of a district justice, once your 6-year term is up, there is open electoral competition for those positions. Anyone else who wants to take on that responsibility. Well, so the lowest level is the district justices. On the same level as the district justice are a whole host of specialized judiciaries. You find that, for example, we have traffic courts in some of the largest, most populous parts of Pennsylvania. Philadelphia and Pittsburgh, for example, have traffic courts where the traffic court will deal with parking tickets and so forth. That could really bog down a district justice in Philadelphia or Pittsburgh. There are family courts where issues of such as divorce and child custody are settled. And there are small claims court, and the level of what is considered to be a small claim varies across the country. But if you, for example, have an issue that is under like $75,000, $50,000, you might go to small claims court. And then you have, of course, drug courts. My caucus and my office and I were very instrumental in that in the late 1980s and early 1990s. We find that drug courts were being used in other parts of the country, and we felt that it was important to have drug courts in Pennsylvania as well. In some of the larger cities where you have higher levels of drug usage, we wanted to have judges that were familiar with the drugs, what their effects were, what effective treatment was, and how to work with those people to try to bring them back and rehabilitate them when possible. So we've established drug courts in Pennsylvania. The most specialized of all courts for the time being has been abolished and doesn't exist, but if a situation develops again, it will reappear. And that I'm talking about a specialized court that only met in Philadelphia, it only met in the autumn, and it only met on Sundays. And of course, what I'm referring to is Eagles Court. Eagles Court developed because Eagles fans were so rowdy for so many years. I mean, remember, these are the fans that threw snowballs at Santa Claus. But you find that I've taken my children to many baseball games, to Phillies games. Everyone's kind to one another, but for some reason, behavior at NFL games had become far coarser. And so, if you are a New York Giants fan and you're in Philadelphia, you had a high probability of having beer dumped on your head. And things were getting so out of hand in the stands that Philadelphia decided to put a small courtroom and a cell in the basement of Veterans Stadium, and then they moved it over to Link Field as well. And they had uniformed and officers throughout the audience who were in plain clothes, and they looked for offenders. They would immediately, when they found an offender, immediately arrest them and take them down to Eagles Court, where they were tried on the spot. They were either held until the end of the game, they were kicked out, or they were put in a paddy wagon and taken down to the police office jail downtown, and held there for a future trial. So we find that actually the Eagles and most people in Philadelphia believe that things got better because of Eagles Court, and this kind of outrageous behavior has subsided. So Eagles Court has been in recess, and we hope that it'll continue to be in recess. But if in fact the Eagles fans begin to act as they have in the past, the Philadelphia Eagles and the National Football League has let it be known that, and the city of Philadelphia, that this will not be tolerated, and the Eagles Court will reopen. Well, so we have these district justices, specialized courts at the lowest level. Above that, you have all the courts, all the appellate courts, the courts of appeal. And the first appellate court would be, of course, the County Court of Common Pleas. The County Court of Common Pleas, how many judges are given to each county? Well, it depends on the county's population. Find that in Pennsylvania, every county is guaranteed 2 judges. And that's what my county had when I first moved back from Virginia. But as the population grows, you find that the number of judges that are assigned to your court grows. There's a catch, though. Each judge is given his or her own courtroom. So it was wonderful when in Lebanon we had more, our population grew, and we were awarded more judicial positions. That was good for guaranteeing a speedy trial, but we had to build more courtrooms. What is true about the County Court of Common Pleas is when you run for this, you can only run when a member loses a retention election or retires. You find that in order to run for the County Court of Common Pleas, there has to be a retirement, a death, or a loss in a retention election. You have, once you obtain a position in this judiciary, you have to face a retention election once every 10 years. Once every 10 years, you go before the people of your county and they're asked, do you want to keep Judge so-and-so? And they vote yes or no. You find that when there is a retirement or a death in office or a loss in a retention election, then it's an open seat, and both Republicans and Democrats can run for it and seek that seat. At least in Pennsylvania. Now, the intermediate appellate courts are found in Harrisburg, and of course here we have the Superior Court and the Commonwealth Court. You find the Superior Court is a general court of appeals. It has 15 judges. The Commonwealth Court is a special court that has 9 judges, and it hears all cases related to government. So you have the Superior Court and the Commonwealth Court as the intermediate appellate courts in Pennsylvania. Finally, at the highest level, we have the Pennsylvania State Supreme Court. Now, they have chambers in Harrisburg, but they also have chambers in Philadelphia and a chamber in Pittsburgh. This is the highest court in the Commonwealth of Pennsylvania. And I want you to know, on the United States Supreme Court, how many people do we have? We have 9 judges, right? 9 judges. In most state Supreme Courts, we have 7. Pennsylvania has 7. You find that the term of office for Supreme Court members in Pennsylvania is 10 years, just as it is for the Court of Common Pleas, so it is for the Supreme Court. The Chief Justice of the Pennsylvania State Supreme Court is simply the individual that has the highest level of seniority. The person who's been there and has served the longest period of time will be the Chief Justice. Oh, there are many observers that believe in a unified court system. And a unified court system is one in which the Chief Justice will act as the administrator for the whole statewide judicial system. In Pennsylvania, we say we have a unified court system, but we really don't have a situation where the Chief Justice has control over the whole state judiciary. So we say we have a unified court system, but I question that. Let's take a look at the structure of the Pennsylvania judiciary. Here I have a slide that will show you this. Let's take a look at this slide, which shows the Supreme Court at the top, Superior Court, the Commonwealth Court at the next level, the County Court of Common Pleas at the next level, and the minor courts at the bottom of the pyramid. This is the structure, of course, of Pennsylvania's judiciary. And again, you have a slide on your PowerPoints that shows exactly this. Okay? All right. Let's move on from the structure of the judiciary. And let's try to wrap up this this section by talking about there are different types of law that you should know about and we need to remember. We have both civil law and we have criminal law. And what is civil law? What's the difference between civil law and criminal law? Criminal law is a body of law that deals with the relationship between the individual and the state. We find that civil law is a body of law that simply regulates relationships among individuals. So very different types of law, and there are two different court systems. Well, I shouldn't say there's two different court systems, but there are two different types of trials. As we look at ways to reform the judicial system, ways to reform the court system, you find that one of the things that we have to be concerned with is America is far and away the most litigious country in the world. And why are we the most litigious country in the world? Simply because we have something called contingency cases. You find that in a contingency case, a lawyer can go to someone who's suffered some wrong and say, I will take this case for you. I will try it for you. I'll be your lawyer and I won't charge you anything. I'll only charge you if we win. And then if we win, I will take a portion of the settlement. Generally, in contingency cases, lawyers take about a third of whatever settlement there is. Contingency cases are things that really drive lawyers to be looking for situations and looking for clients that might be able to go ahead and file a lawsuit. And in many instances, people are, rather than fighting the lawsuit, it's simpler and will be cheaper to just settle out of court. And that's a way that lawyers can make a good bit of money. Well, the way that we can avoid this litigiousness and contingency lawsuits is simply by using the English system of law. The English system of law eliminates all frivolous lawsuits simply by requiring that the losing party at every court case pays the legal costs for themselves and for the other side. So if you know that you're going to have to pay your own legal costs and the legal fees for the other side, if you lose the case, you're going to really take a look at the situation soberly and decide if you really want to go ahead and file that lawsuit. So the English system has done a great job, at least in the United Kingdom, eliminating frivolous lawsuits. There are a couple terms that I want you to be familiar with when we are considering the judiciary. I want you to be aware of the issue of standing. Standing is who has the right to file a lawsuit. Do you have standing? But take a look at the definition of standing. Take a look at strict and loose constructionists. Of course, strict constructionists were individuals who believe that you shouldn't be interpreting the Constitution. You should simply implement and administer the law as it is written. These are strict constructionists. That would be a Jeffersonian position. This is what Thomas Jefferson would believe in. Loose constructionists would be Alexander Hamilton. These are individuals, for example, who believe that the Constitution is a living document and you must interpret it in light of the changing times. So they believe that the Constitution changes as the times change. So strict and loose constructionists. Take a look at class action lawsuits. Of course, these are lawsuits that are filed on behalf of someone in a particular situation in all other people that are similarly situated, all other individuals who are similarly situated. This would be for a case, for example, where several years ago, one of the medical companies put out a defective hip, an artificial hip, and the artificial hip was used widely across the country. And once we knew that it was defective, the people who had it implanted all joined together, and in one lawsuit, in the class action lawsuit, they sued the manufacturer for new hips and for the fees to insert them and repair the damage. So class action lawsuits, take a look at judicial federalism, take a look at what is a bench trial, of course a trial without a jury, trial decided by the judge. Take a look at jurisdiction, what jurisdiction is and how it works. Take a look at jury nullification. Of course, this is what we found in the O.J. Simpson case, where O.J.'s lawyers were very crafty and cunning and very intelligent in terms of selecting or agreeing to who could be a jurist, who they would allow to sit on the jury and who they wouldn't. They wanted to make sure that they could nullify whatever evidence that the prosecution could present. And then I want you to look at indeterminate sentencing as well. So those are 10 terms I want you to be familiar with. Take a look at them, please. And if you have questions about the judiciary, please give me a ring. And if I can't answer them, I'm sure Dr. Glenn can. Of course, Dr. Glenn, we're fortunate to have him because he teaches all our con law courses and the American Judiciary course that we have. So if you're more interested in the judiciary and would like to go to law school, I would recommend that you take a good hard look at his courses and sign up. All right, we'll be back with the next subject after this.